The concept of PIL has now turned into personal interest litigation and is at times being misused to stall projects or put pressure on public authorities. Every year, thousands of frivolous petitions are now filed in courts, burdening the Indian judicial system. An international conference organized on the theme PIL, a tool in the present time, a balanced outlook, saw the convergence of legal luminaries to allow empirical assessment of PIL. The rich discussions at the conference uncovered the pitfalls and drawbacks of PIL and also shed light on the ongoing trend of filing PILs to settle a personal vendetta and serve political or business interests.
In my view, there has to be a balance which has to be struck, because while we have good causes, we also have these frivolous kind of litigations, and I think which is why way back in 1988, the Supreme Court had come out with certain guidelines which required the scrutiny before a PIL is actually entertained, whether a party is acting in good faith, whether there's an oblique political or personal motive. And of course, now the courts have been distinguishing between what we call as a public interest, private, paisa earning litigation. And therefore, the Supreme Court then in 1988 carved out certain categories which could be entertained as a letters petition, delineated certain categories which would never be entertained as a PIL. Justice Dalveer Bhandari, as we all know, in state of Uttaranchal, had also found it imperative to pass a detailed list of directives to preserve the purity and sanctity of a PIL, and all the high courts today across the country have followed those guidelines. And which is when Justice Nawaz said that on a letter one could entertain a PIL, I would only add that today we have very, very strict standards where before a PIL is entertained, at the time of drafting, a person, no doubt the locus is completely now been loosened, but you will have to indicate who you are as a petitioner, what is your locus standi, what is your motive, do you have any connect with the agenda that you're trying to raise. So these are some of the tests which the courts at the very outset go into, and if they find that there is a motive, they are not only dismissed, they are dismissed with exemplary costs. And that's the message I think largely needs to go down.
The other quarter says basically that shoring off the processes actually burdens the court with a lot of litigation and their time. So these two factions of argument on public interest litigation is standing. And these arguments have changed over the years. 1970 public interest litigation started. And now when we look at after 1991 liberalization and economic development, there is a talk of balance between these two thoughts now. So there has to be a balance between entertaining public interest litigation and at the same time stopping publicity interest litigation. So this is what should be the ideal way to look at it.
So political party, every party when they comes to power, in order to protect their own party, they are throwing their personal agendas. But leaving aside, they have to really understand the ground root of the problem. Understanding the sensitivity, the human values, the rights involved in the people.
It takes a robust judiciary to see through this and see whether there is a public element in that. So if that is the case, it's up to the judiciary to really scrutinize the motives, scrutinize the parties behind the case, and then cull it out of the system.
Public interest litigation. It is for the general public. It has been drafted for the poor class people who cannot afford the court. And now in recent time, it has been misused and inappropriately used by public. For instance, in the case Prasna Ananda versus State of Delhi, in which petitioner filed the case against State of Delhi, which states that the government funding for COVID-19 pandemic was misappropriately used. Later on, the court observed that the petition was filed on the mere tweet. The court dismissed the case and imposed the cost of 50,000 on petitioner.
I was posted in Rajasthan after elevation for little less than 2 years, and I happened to be on the PIL bench with the Chief Justice for quite some time. There was a tiger known as, they are all named, T24. He had developed strange behavior. He attacked a forest guard, also led to his life. And then the forest officials, in consultation with experts, decided to relocate him to the biological park that's in Sajjangarh near Udaipur. And there was tremendous uproar, candlelight marches and whatnot. This is why the tiger is being dislocated. We got a PIL on the subject. He said the tiger cannot be dislocated. We asked him, are you an expert in wildlife? And because he had said, I am a real estate person indulging in real estate business, but I am a wildlife enthusiast. But he had no credentials. We immediately dismissed it. I said, this has been done on the opinion of the experts, wildlife experts. So the tiger was dislocated. The order was upheld by the Supreme Court. Then after some time, there were reports in the newspaper that the tiger developed some problems, intestinal problems at the biological park. But he was being well looked after. There were veterinary doctors, probably they were planning a surgery. Then another PIL by somebody else. You say, now you have sent him there. See, he's not been able to adapt himself. And you please send him back. We were appalled at this argument. Tiger is unwell. He is being treated by doctors there, veterinary. And they are saying, no, leave him in the wild. And had he left him in the wild, it would have been a matter of few days for him to survive. So these kind of petitions have been coming. So half-baked petitions, they have not done adequate research on the subject. So that, of course, was dismissed.
Honorable Supreme Court and High Courts in India have time and again stressed how frivolous petitions, instead of fulfilling the objective of PIL, damage the public good. Today, it has become essential to curb the misuse and abuse of PIL. According to the legal luminaries, there is an urgent need to develop a framework to protect infrastructure projects from delays on account of litigation and save the time and energy spent on ineffectual PIL cases at the expense of real administration of justice. Time to preserve the purity and sanctity of PIL.